Start. Para. Through the present petition, the petitioner is asking for the relief that the respondent state be directed to amend Rule 11 of the Maharashtra Law Officers (Appointment, Conditions of Service and Remuneration) Rules 1984 by providing reservation of seats for various backward classes and tribes while making the appointments of government pleaders and public prosecutors. In the alternative, he has asked for the relief in the nature of declaration of Rule 11 as unconstitutional and for striking down the same. He has also prayed the appointment of the respondent number 2 as government pleader in the High Court of Bombay bench at Aurangabad be cancelled. Along with the above said reliefs, the petitioner also has asked for certain ancillary reliefs. To understand the case of the petitioner and to find out his entitlement for reliefs, he has asked for it would be necessary to narrate the facts of the case in short. Para. Petitioner, a scheduled caste candidate, is practicing as an advocate and is resident of Aurangabad. He claims to be Mahar by caste. At the time of filing of the petition, the petitioner had completed about 11 years of his practice in various courts referred to in his petition, including the High Court. The petitioner at the relevant time was desirous of working as a government pleader or additional government pleader in the High Court, or as a government pleader, public prosecutor or additional public prosecutor in the same court, or as a district government pleader or assistant government pleader in the district court Aurangabad. Para. It is necessary to mention that during the relevant period, original respondent number 2, Sri J.V. Sawant, was appointed as a government pleader by the respondent number 1, State of Maharashtra, to work as such in the High Court of Bombay bench at Aurangabad. The petitioner in his petition challenged the appointment of the respondent number 2 as a government pleader on various grounds. However, during the pendency of this petition in the year 1989, the petitioner deleted the name of the respondent number 2. He also deleted the names of the respondents 3, 4 and 5 who, according to the petitioner, were instrumental for respondent number 2's appointment as a government pleader. In view of this deletion, the various allegations against the respondent petition now are not required to be gone into. For the purposes of the decision of the present petition, the petitioner was, however, permitted to amend his petition by an order dated 19/2/1987, whereby he amended the petition by adding paragraphs 16A to 16D. This court is now therefore called upon to give its decision on the grounds which are raised by way of amendment. Para. It is the case of the petitioner that there were directions issued by the State of Maharashtra to all the government authorities to provide certain percentage of reservation for the backward classes, not only at the stage of recruitment but also at the stages of promotions. According to him, necessary concessions with regard to the relaxation of age in the service are also required to be given in favor of those candidates. In short, it is the case of the petitioner that, in accordance with the aims and objects of the Constitution of India, the principles of equality as enshrined in Article 16 of the Constitution are to be observed even in the matter of appointment as government pleader or assistant government pleader and public prosecutors. He argued that to avoid the possibility of any discrimination as is contemplated under Article 15 of the Constitution of India, reservation should have been provided for in the matter of their appointments. In support of his contentions, the petitioner has placed on record a copy of the Government Resolution number BCC/1072 dated 3/5/1974. He has also placed on the record a government circular bearing number BCC/1078-16B dated 31/5/1979, which, according to the petitioner, is a comprehensive circular covering all aspects of service matters pertaining to backward classes and precisely dealing with the point of reservation. On the basis of these documents alone, the petitioner contended that it was incumbent on the state to have kept appropriate percentage of reservation for the scheduled caste and scheduled tribes candidates and for other backward classes, which, according to the petitioner, is lacking in the rules framed by the government. Stop.